All right, so thank you for joining our webinar. I hope that this information will be useful for you, and you will not regret the time you will spend with us. How it works. Here's the agenda for the next hour. As you can see, we will speak on the regulatory changes, price regulations, which is a very hot topic now. We will, for the time's sake, we will speak on the major issues. But if you are interested in details, I would invite you to sign up for our seminar tomorrow. And my colleagues will speak specifically on this topic for more than 2 hours. Then we'll talk on the public procurements and competition legislation. I used to say that competition legislation is one of the most stable legislation in Ukraine. Any changes in this sphere occur very rarely, not very often. However, we have the Anti-Monopoly Committee of Ukraine, and this institution is very proactive. It creates its own practice, and the business has to follow it. So my colleagues speak more on that, and specifically on the recent report which the Anti-Monopoly Committee issued. We will also speak on the new licensing requirements or terms, and the new concept note on reforming the Ukrainian healthcare system. If you have any questions, please write us. We'll try to answer those at the end of the webinar. If we run out of time, we will respond by email or on our website. Well, I'm not sure how it works, but we will definitely answer them. Before I start speaking about the regulatory changes, I would like to mention that our partner marketing, SMD marketing company, provided us with a slide on the main trends on the pharmaceutical market. So I would like to start with that first. On this slide, you can see the diagram which illustrates the market trends in foreign currency for a significant period of time. It starts from 2004 and up to the moment. At present, the market demonstrates some stability, and there are some signs of growth in local currency, but there are still negative trends in units and in foreign currency. The prices for the local products continue to grow, while foreign producers try to regain their lost positions, mainly in volume. And there are a number of factors which affect the market, but I would like to mention a few of them, which are, in my opinion, pretty much the same which were last year. Those are the war in military conflict in the eastern Ukraine, significant migration of the population, high inflation rate, and of course the decline in the income of people. The market is still financed mainly by consumers, about 85%. There are only certain nosologies, certain diseases which are financed or partially financed by certain state programs. So this is a general picture on the market, and now we move to the regulatory changes in the pharmaceutical sphere. And here I would like to start with the simplified registration procedure for medicines. In summer this year, the law of Ukraine number 1396 came into effect, which introduced some amendments to Article 9 of the law of Ukraine on medicines. Basically, such amendments created the foundation for the simplified registration procedure for some category of medicines. The cabinet ministers of Ukraine, according to the law, the cabinet of ministers of Ukraine introduced some amendments to its resolution number 376, which establishes the procedure for the registration of medicines. What does the simplified registration procedure mean? Basically, it determines that certain medicines which may be registered in Ukraine under the simplified procedure, provided that those medicines were registered by the competent authorities in the countries with the strict regulatory policy, such as like the United States of America, Japan, Switzerland, Australia, Canada, and as well as by the competent authorities of the European Union under the centralized procedure. This simplified registration procedure basically envisages that the period of registration is shortened. Now it constitutes 17 business days, and the State Expert Center will have 10 business days for to review the registration materials and come to its conclusions, and then the Ministry of Health will have 7 business days to make the final decision. On the right side of the slide, you can see the shortened list of documents which shall be submitted for the registration of the medicines. I would like to draw your attention to the fact that the State Expert Center shall not conduct expert study of the registration dossier files within this simplified procedure, registration procedure. National policy on medicinal products. As you know, the government declared declared the national policy on medicinal products early this year. The national policy has a number of objectives, and we pointed out a few of them here. Those are the accessibility, high quality, and rational use of medicines. The national policy has 9 separate directions, and You can see those on the slide. I will not read them, but I would like to draw your attention to the first one because I will speak more on that in a second. This is selection of essential medicines. So basically, it means the creation of the national list of medicines. Such national policy on medicinal products is expected to be approved in the first quarter of the next year. National list of medicinal products. In January this year, the resolution of Cabinet of Ministers number 1134 came into effect. This resolution introduced changes to several other resolutions of the Cabinet of Ministers, and as you can see on the slide, the name of the national list of essential medicinal products was adjusted because this list does not contain the medical products. Also, the Ministry of Health was obliged to adopt a number of regulations. Those are the regulations on the national list of essential medical products, regulation on expert committee on selection and use of essential medicinal products, and regulations on selection of medicinal products. The respective regulations were approved by the orders of the Ministry of Health. There are two of them, and the first one is the order number 84, which this order approved two regulations: the regulations on the national list of essential medicine products and the regulations on expert committee. According to these documents, the criteria for selection of medicines were established. And I would like to draw your attention to the fact that one of the of such criteria is the impact on the budget. The national list will consist of INN, and it will include registered and unregistered medicines in Ukraine. It will be reviewed once in a year, and the expert committee will have to publish the respective reports on a yearly basis. This national list again is expected to come into to be approved in the first quarter of the next year. Another order of the Ministry of Health is number 1050. This order approved the regulations on selection of medicinal products for their inclusion to the national list. And here you can see the general stages of the expert committee's work in this regard. First, the expert committee identifies the list of the priority diseases and disorders and conditions. Then it prepares a recommended edition of the national list, taken into account the information which was identified, as well as the basic list of essential medicines recommended by the WHO. Then the expert committee shall improve the recommended edition of the national list if necessary, considering the industry's standards. And only after this, the national list uh, may be approved by the Cabinet of Ministers of Ukraine. Here you can see how the procedure for the review of the national list looks like. First, the expert committee shall review the list of priority diseases, disorders, and conditions by October 1st of the current year. So, for example, if we take this year as an example, so by October 1st, the expert committee had to review, all those, and then by November 1st. It had to review the national list for the next year. Then the expert committee also collects the applications on, amendments of the national list by the 1st April of the next year. So in our case, it will be 2017. And by the 1st of June, it shall examine all those applications and then, come to certain conclusions. By the 1st of June on the next year, the expert committee shall submit a recommended addition of the national list to the Ministry of Health, and the Ministry of Health will review it and prepare it for the approval by the Cabinet of Ministers of Ukraine. Price regulations. As I have already said, this is a very hot topic, and there are a number of reasons for that, but I should probably start from the declaration of the Prime Minister in spring this year, when he said that, or declared that the prices for medicinal products should be reduced at least by 30%. The Ministry of Health was authorized to elaborate the respective mechanism for that, and consequently, the working group was created, which developed, several drafts of the resolutions, which were widely discussed by different experts, lawyers, and business. And then in November this year, the Cabinet of Ministers of Ukraine finally adopted two closely connected resolutions, one on the state regulation of, of prices and for medicinal products, and the other one on the cost reimbursement. The wording of those resolutions, it was a real surprise for the experts, business, and in my opinion, even the ministry itself to some extent. And the present, different experts, lawyers have different opinion regarding how those resolutions shall be interpreted. The declaration of the Minister of Health, just recently clarified the situation a little bit, but it is obvious that the resolutions require improvement, and hopefully it will be done very soon. Anyway, so what does those resolutions really envisage? Let's start with the resolution number 862 on on price regulation. The resolution envisages the necessity to establish maximum prices for medicinal products by way of using reference prices by the Ministry of Health. It also establishes maximum markups, but only for the reimbursable medicines. And the way we read this resolution, we understand that basically it means the 21 INN for treatment of hypertensive diseases, certain type of diabetes, and asthma, which listed in the resolution of the Cabinet of Ministers number 863. Besides, this resolution cancels the maximum markups which were established by another resolution of the Cabinet of Ministers number 955. So let's see what the resolution really says. Starting from January 1st, 2017, let me read it. The resolution is applicable to medicines registered in Ukraine, included in the national list of essential medicinal products, considered. Costs of which will be reimbursed in the outpatient treatment of persons suffering from hypertensive disease, type 2 diabetes, and asthma. All right, so all those nosologies or diseases are indicated in the list approved by the resolution number 863. The other provision says that this resolution is also applicable to medicines included in the list of international non-proprietary names of medicines which costs are reimbursable. So in my opinion, the first and the second provisions, they are basically mean the same thing. They are referring to the same list of medicinal products, namely the list approved by the resolution number 863. If was it an intention of the Ministry of Health or the Cabinet of Ministers of Ukraine? I doubt. Besides, the resolution establishes the reference countries. You can see those on this slide as well. They are Hungary, Latvia, Poland, Slovakia, and Czech Republic. Maybe this slide clarifies the picture a little bit. I understand that it's a little bit confusing. What do we have now? Now we have the 10% wholesale markup and 25 retail markup established by the resolution of the Cabinet of Ministers number 955 regarding the medicines included in the national list of essential medicines approved by the resolution number 333. The maximum prices for this category of medicines are not established by the resolution number 240. On the other hand, we have the medicines which are procured using the state funds and under the resolution of the Cabinet of Ministers number 1071. For those medicines, we have 10% wholesale, we have 10% markup. Besides, resolution of the Cabinet of Ministers number 240 envisages that the prices for such products shall be declared and listed in the registry of wholesale prices. So, taking into account the resolution number 862, which we have just discussed, starting from January 1st, the markups established by the resolution number 955 are cancelled. So they may not be applied, and we have only the 5% wholesale markup and 15% retail markup for the products listed in the resolution number 8663. Again, I'm talking about those 21 INN. Besides, the Ministry of Health shall elaborate the procedure for determining such markups. You know, we understand that it may take some time, and even if the minister develops that, say, you know, prepares a draft in January, it will have to place it for public discussion and it's another month. So if such procedure is adopted, say in February, you know, that's the earliest. So it sounds like a deplorable picture, doesn't it? Now on the resolution number 863, I have already mentioned it several times today. This resolution envisages that starting from April 1st, 2017, there will be a possibility for cost reimbursement for a certain category of medicines. Those medicines, I mean the medicines which are registered in Ukraine, included into the national list of essential medicines, and used for treatment of hypertensive disease and type 2 diabetes and asthma. And those medicines which fall in line with 21 INN approved by this resolution. Besides, the resolution envisages that the Ministry of Health shall adopt the procedure on determination of the amount of reimbursement, and such information shall be openly available. So the minister will have to put it in, make it available in the open sources. Again, the 5 and 15% markups are applicable to these medicines, and Now, I guess you have the same question as I do. I mean, whether this is a sufficient markup taken into account a significant inflation rate in Ukraine. Probably not. Probably the respective procedure for review of the of such amounts shall be established. So again, here's just a general information on this topic. If you want to have more information, I would strongly recommend you to contact our marketing department, and they will be happy to get registered you for the seminar on this topic tomorrow. Public procurements. Let me see how much time I have. Not much. All right. So now, when we are talking about the state procurements, we mean basically two separate directions. The first one is the procurements which are performed via Prozoro electronic system, and on the other hand, we have the procurements which are performed by the specialized international organizations. It shall be noted that these international procurements are performed according to the internal rules and procedures of the international organizations, and the law of Ukraine on public procurements is not applicable to them. So let me say first a few words on the international procurements. I would like to emphasize that this year 4 organizations were selected by the ministry to perform such procurements. You can see those on this slide, and the Ministry of Health concluded the respective contracts with the first 3, and at this moment the contract is not concluded with the Partnership for Supply Chain Management. Most likely, this contract will not be signed this year, and I expect that the Minister of Health will try to enter into the contract with this organization next year. So basically, we have the same 3 organizations which performed the procurements last year. The Cabinet of Ministers of Ukraine approved the resolution number 557, which establishes the list of medicines and medical products which may be procured by these specialized organizations under the budget program for this year. I should say that the list, this resolution contains contains the provision of which allows the specialized organizations perform additional procurements provided they have completed successfully all procurements which were requested by the Ministry of Health. And they still have enough savings for those. So in this case, they may they report to the ministry and say report to the ministry on the amount of their savings, and the ministry will decide what kind of products they may additionally purchase under the program. Besides, I would like to draw attention to the resolution number 622. This is the resolution which establishes the criteria for selection of specialized organizations. In August this year, some amendments were introduced into this resolution, specifically such criteria as price for goods was cancelled, and the reason for that is that the specialized, at the moment of selection of specialized organizations, they do not have such information. They do not have information on price of goods because they, at that moment, they have not yet conducted any tenders. So, in my opinion, this is a very logical amendment. On this slide, you still can see the issues which, in my opinion, shall be resolved in order to ensure the smooth international procurements. First of all, I would like to say acts contain the reference to the law of Ukraine on conduct of state procurements, which became void on August 1st. So the respective amendments need to be introduced into a number of those legal acts. Besides, the situation with VAT exemption was not really resolved on the was not really resolved. There were several drafts developed which which meant introduction of certain changes to the tax code of Ukraine to resolve this situation. However, at this point, none of those drafts was really passed by the Supreme Court, by the Supreme Council, by Verkhovna Rada. At the same time, we have a monopoly on the state entities of the Ministry of Health in the sphere of delivery of the products procured within this procedure on the territory of Ukraine. As far as I am aware of the situation, the ministry is still considering the possibility of introducing the changes to the resolution of the Cabinet of Ministers number 622 and envisage the possibility of other private logistics companies to participate in this. This would increase the competition on the market and would improve the quality of the services provided by the logistics organizations. Besides, in my opinion, there are private logistics companies which have a better technical base, equipment and facilities, which would allow it to deliver the products faster and ensure high quality of storage and delivery. And besides, as we all know, the maximum products shall be supplied to Ukraine within 90 days, established by the resolution of the National Bank of Ukraine in the sphere of currency control. In many cases, this period is not sufficient. In my opinion, it would be logical to introduce the respective amendments to the law of Ukraine in the sphere of currency control, or at least to the resolution of the National Bank of Ukraine. Besides, the cooperation between the specialized organization and the ministry shall be improved, in my opinion. From the experience of the previous year, we know that the requests or the questions which the specialized organizations had were not answered for for a significant amount of time, and it resulted in delays of the product's delivery. I should also draw your attention to the fact that this mechanism of international procurements is temporary, and the significant work shall be done to reform the sphere of state procurements of medicinal products and medical devices. At this point, we have the concept note on this reform, which was approved by the departments of the Ministry of Health, and was submitted for approval by the Ministry of Finance and the Ministry of Economic Development and Trade of Ukraine. As far as I know, at this point, there's no feedback from those ministries. And I think it is crucial to accelerate the work in this direction. Well, on this slide, you can see those legal acts which still contain the reference to the previous law on conduct of state procurements, which became void, as I have already said, except for the cabinet. There was the resolution of the Cabinet of Ministers number 622, the amendments to which have already been introduced. Now we move to the public procurements via Prozoro electronic system. Here I should start from the Well, uh, um, I, I should probably start from that the law of Ukraine. Well, this electronic system, Prozoro electronic system, was uh, let me paraphrase it a little bit. The law of Ukraine on public procurements basically created the legislative foundation for implementation of this Prozoro electronic system. This law was adopted at the end of the last year, 2015, and became effective in February. Then the law became binding starting from April 1st. It became binding for central executive authorities and for certain buyers in the specific spheres of economic activities. And starting from the August 1st, it became binding for all the buyers for all the procurements. So there were two stages of this law implementation. As all previous laws on public procurements, this law is applicable provided or is obligatory or compulsory for use provided the procurement provided the procurement subject has a certain value, as a certain value threshold. As you can see on this slide, if the value of the procurement subject constitute no less than 200,000 hryvnia for goods and services, it means that the buyers shall conduct on if the value of the procurement subject is lower than that, the buyer actually has options whether it should conduct the procurement through the electronic through the Prozoro electronic system or not. On this slide, you can see that provided the value of the procurement subject constitutes less than 50,000 hryvnia for goods, for goods, services, and works, then in this case, it is optional for buyers whether to use the Prozoro system or not. However, if the procurement subject is between 50,000 hryvnia and 200,000 hryvnia for goods and services, then in this case, the buyers still have an option whether they want to use the Prozoro electronic system, but in any way, they will have to publish the reports on the concluded contracts in the Prozoro system. So in this part, the requirements of the law are compulsory for them.
The law of Ukraine on public procurement envisages 3 procurement procedures. Those are open tenders or open bids, and this is the main and the most transparent procedure. This procedure is widely used, and including for the procurement of medicinal products and medical devices. The other procedure is competitive dialogue, and this procedure is used in certain cases for the procurement of certain, for certain procurements. I will not, for the time's sake, I will not speak on this competitive dialogue because it is basically not applicable to the procurement of medicines and medical devices. And the last procedure is called negotiable procurement procedure. It is the procedure which we used to know as the procurement from a single seller. And this procedure is also used in certain cases as an exception. On this slide, you can see a general procedure for open tenders. The first stage is publication of the tender announcement and tender documentation on through the electronic Prozoro electronic system, and it shall be published no later than 15 days prior to the date when the tender proposals are disclosed. Again, of course, there are exceptions. I will speak only on the general procedure here. Another stage is submission of the tender offers in the electronic through the electronic system by the participants or potential participants. Then disclosure of the information about the price of the offer, electronic auction, examination of the tender proposals for compliance with the requirements of the tender documentation, selection of the winner, and conclusion of the contract, respectively. The participants under the law on public procurements, the participants have a right to address the buyer if they have any questions regarding the tender documentation, or if there's a certain violation, or if the tender documentation contains a certain violations of their rights with the law. Such, the participants may address the buyer anonymously through the electronic system, but they have to do that no later than 10 days prior to the deadline for submitting the tender proposals. The buyer shall respond to such requests within 3 working days, and if there are any amendments to the tender documentations, the period for submitting a tender proposal still shall be no less than 7 days. If such period is is shorter, then the buyer shall prolong the day for the submission of the tender proposals.
The again, as well as the previous, like the previous law, they said the current law on public procurements established certain periods within which the buyer shall conclude a contract with the winner on the tender. And such contract shall be concluded no later than 20 days from the date when the winner was selected, but no earlier than 10 days after the date of publication of a notice about the intention to conclude a contract. These 10 days are given for the participants to appeal the decision of the buyer if they disagree with that and if there are grounds for that. The terms of the procurement contract shall not differ from the accepted tender offer. Basically, there's no change in this part. The same this provision migrated from the previous law, and there are only exceptions when the essential terms of the contract may be changed, and those exceptions are stipulated in Article 36 of the law. The Anti-Monopoly Committee of Ukraine, excuse me, the Anti-Monopoly Committee of Ukraine remains the authority of appeal. So if the participants are not happy with the decision of the buyer, and there are grounds for when there are justified reasons for that, they may appeal to the Anti-Monopoly Committee of Ukraine and through the electronic procurement system. There's certain requirements with regard to the scope of the claim, and you can see the main things on this slide, and it is all those are envisaged by Article 18 of the Law on Public Procurements. The Anti-Monopoly Committee of Ukraine shall review those claims within 15 working days, and upon making the decision within 1 working day, it shall place the operative part of its decision in the electronic procurement system. And then within 3 working days, the full text of this decision shall be published. So that's about it shortly, and now, I'm sorry that it took longer than I expected. Now my colleague will continue on the competition legislation and on the rest of the presentation. Thank you.
Good afternoon, dear friends. My name is Zemichovska, and I would like to proceed with the changes in the competition sphere of 2016. Despite the fact that there have been no changes in the legislation regarding the protection of economic competition, the Anti-Monopoly Committee of Ukraine continues to pay special attention to the pharmaceutical market. As you probably know, in 2016, the committee issued 2 cases regarding the analyzing and evaluating of relations between the international pharmaceutical companies Alcon and Serbia and Ukrainian distributors. Based on the information obtained from the parties and based on the comprehensive and deep analyzing of distributor contracts, the committee charged all the parties with huge fines for the anti-competitive concerted actions in the form of setting of prices, setting control over the market, and allocation of market in accordance with consumers. The peculiarity of this case is that within its investigation, the committee elaborated and used new approaches to the understanding of anti-competitive concerted actions in the mentioned forms and interpreting of each of these violations. Consequently, I suggest to look precisely at what actions of the parties were identified by the committee as each of the mentioned violations that you can see on this slide, and what contract provisions confirm in the committee's point of view existence of violations by the parties. The first one is setting of prices. By setting of prices based on the conclusions made in the Alcon and Serbia cases, the committee understood the situation when, let's imagine, distributors were obliged to not to re-export medicines, and at the same time all the medicines shall be bought through the affiliated body of the producer. And for the medicines from the very beginning, the producer set overcharged economically unjustified prices. Later on, in order to participate in public procurement in accordance with Ukrainian legislation, such unjustified overcharged prices were declared, and later on this overcharged price was used in formulation of prices for the final consumer. But at the same time, the distributors were provided by special discounts by the producer for the participation in the state procurements. The trick is that such discounts they were provided to distributors exposed, that is for the further for the next purchase, for the next supply, and consequently these discounts were not included into the prices while formulating it for the final consumers. So as a result of all of these actions, and the final consumer obtained economically unjustified price due to the fact that, in fact, as the committee identified within the conclusions in the mentioned cases, there were 2 prices basically. A nominal one used by the for the state procurements, overcharged and economically unjustified, that was later on used for final consumers, and real one that was used for distributors, including the price with discounts. And by the way, the committee classified such discounts as solely as additional financial benefits for the distributor. The next violation is setting control over the market. The committee detected that in case when producer controls the import of the medicines, when the producer prohibits re-export of medicines, and in case when distributors are obliged to provide their producer with information regarding the circulation of the goods and supply and demand. All of these actions result in setting control over the market by the producer. What I mean is that producer, by these actions, is empowered to start and to stop commodity flows, to control the intensity of supply and demand, and to decide what products in what quantity and for whom, for what the consumers will be supplied. All of the mentioned shall be classified precisely as setting control over the market. The next violation is allocation of market in accordance with consumer cycle. What the committee meant is basically the situation when the producer provides special discounts only for single distributor, and only for the cases when this distributor provides or supplies goods to certain consumers. The problem is that by such actions, other distributors, they are eliminated from the entrance into the market, and they are restricted to compete actually. And in addition, there could be other distributors that provide the same medicines for the same consumers, but for a big surprise, they are not provided with the same discounts. In order to confirm existence of all of the mentioned violations, the committee pointed specific provisions that prove existence of the agreement between the parties to restrict the competition. What we are talking about are the following contract provisions: restriction of import, restriction of distribution territories through only one affiliated body of the producer, setting on any additional discounts for such affiliated body of the producer, restriction or even direct prohibition of re-export, obligation for the distributor to provide reports on circulation of goods and circulation among the clients, consumers, in fixed period of times, for instance, monthly. Another risky provisions in the committee's point of view are provisions regarding special discounts and individual discounts for particular distributors, and conditional discounts or discounts that do not achieve the declared goals. For instance, in the situation when the parties declare that they agree on special discounts for a distributor in order to increase the supply of the goods for a particular depressed, let's say, depressed region, but at the same time, other distributors also act on this territory, but nevertheless they do not have such discounts. So the committee presumes that, in fact, the parties had different goals than that one that was declared. In order to mitigate all the risk, we recommend you to review your contracts or considering existence of any of the mentioned risky provisions. If you do have some, we recommend to examine your situation at the market. What I mean is that you need to evaluate the market share that you own. Later, you need to evaluate as well the influence that your relations with distributors and your provided discounts, any discounts or financial benefits for the distributors may have for the competition at the market. Of course, you need to elaborate and use the mechanism of risk mitigation. Nevertheless, it shall be emphasized that despite the fact that recently the Anti-Monopoly Committee uses more comprehensive and deep approaches for the understanding of the competition and the market, it still narrows the understanding of the crucial of core terms, core definitions such as the market itself and control over the market. Moreover, it shall be emphasized that there is no legal definition of the control over the market and market itself. Thus, each time the committee evaluates the situation ad hoc. Based on all of the mentioned, we highly recommend to apply for the committee's conclusions in the form of recommendation clarification. As a result of such actions, you will understand which approach the committee actually uses, and you will obtain an opportunity to amend your provisions or to elaborate new relations with your distributor. Another issue that shall be discussed within this webinar is the report on pharmaceutical market made by the committee regarding evaluation of the situation on during 2014 and 2016. This time, the committee focused at three main directions. The first one relates to the analysis of relations between the main parties, the main players at the pharmaceutical market, producer, importer, distributor, and pharmacies, and their compliance with law and economic competition protection. Secondly, the committee identified influence of manufacturers, importers, and distributors on the formulation of price on medicines. And thirdly, finally, the committee analyzed the situation at the retail segment of the market. Once again, within this report, the committee discussed the main conclusions made within the Elkan and Sevier cases. What I mean is that if you have any restriction of the import of goods in your contracts, as well as prohibition for the distribution for re-export, and also if you envisaged within your contracts for the obligation for the distributor to provide reports on the fixed period of time, annual, monthly, or daily, there is a high risk that all of these actions will be classified by the committee as anti-competitive concerted actions, and in fact, they, in the committee's point of view, will lead to the implementation of duplicate pricing, nominal one overcharged, economically unjustified for the final consumer, and one real one considering the discounts provided for the distributor, that will be much more lower. Within the report, the committee also highlighted main objective factors that have an impact for formulation of prices on medicines. Among the list of such factors, the committee identified Ukrainian currency exchange rate, inflation rate, changes in taxation system, and introduction of additional import fee. As it has been highlighted within the report, the manufacturers frequently changed the price on medicines based on the changes in the prices and currency rates in Ukraine. Moreover, the committee stressed that while formulating wholesale and retail prices on medicines, the distributors of the medicines of foreign region frequently added all the financial risks into the price for the final consumer. What I mean is that in fact, the final consumer was obliged to pay for all the financial risks, and the price that the distributors formed, that prices were not economically justified. And finally, in the report, the relations between the distributors and pharmacies have been analyzed by the committee. Within the process of the retail sales of the medicines, the Anti-Monopoly Committee emphasized that the majority of pharmacy chains, despite the incorporation form, during the organization of the retail sales of medicines, render marketing services for the importers and national manufacturers. As it was identified within the report, the parties envisaged certain financial benefits for the pharmacies based on the volume of the sold medicines. The medicines from the list purchased from that particular manufacturers and importers. And if such financial benefits result in any of the consequences that you may see on this slide, in the committee's point of view, there is a high risk of violation of the legislation on protection of economic competition. Of course, within this webinar, we need to discuss with you the main draft bylaws that, in our professional opinion, will influence the pharmaceutical market in the next years. And for today, we have chosen two of them. One relates to the new license requirements. In this case, we are talking about the resolution of the Cabinet of Ministers, number 929, dated on 9th of November this year. I shall emphasize that this resolution has not come into effect yet, due to the reason that it has not been yet officially published. Among the main notions that you need to remember regarding these new license requirements is that previously different types of activities that are subject for license were regulated by two separate documents, and now after the new license requirements come into effect, there will be only one legal document, and this resolution of the Cabinet of Ministers, that will envisage all the exhaustive list of the requirements for the applicant for each of the activities, namely manufacturing, wholesale, retail, trade, and import of the medicines. Another core issue in the obligation set for the applicant to indicate information about location of performance of activities for each type of activity subject to obtaining a license. if the body, if an applicant does not indicate all of such locations, he or she, basically it will have no right to carry to conduct the activity. And other requirements that are stipulated by the license, by the resolution of the Cabinet of Ministers are unified qualification, organizational and special criteria to a licensee. Especially you need to pay attention to the criteria set for retail trade of the medicines. Furthermore, you need to bear in mind new requirements for medicinal products quality. And the most crucial thing is that for all the applicants and for all subjects who currently has license on any of the activity, manufacturing, wholesale, retail, or import, they need to comply the activities with the new requirements within 2 months after the new license requirements come into force. However, particular provisions regarding import of medicines will enter into force only with the beginning of the March of 2018. The next change that will significantly influence the pharmaceutical market is draft resolution of the Cabinet of Ministers on concept of reform of Ukrainian healthcare system financing. The process of transition to a new model of financing will be gradual and scheduled for 3 years, with the final adoption in 2020. The Ministry of Healthcare of Ukraine introduces the notion of a guaranteed package of healthcare. That is, in fact, clearly a defined set of medical services and medicines, the right to which will be provided to all citizens of Ukraine. This guaranteed package of medical aid will be annually reviewed and published. The next crucial notion within the concept of reform is an establishment of the single national customer procurer national healthcare financing agency. This agency will regulate the relationship between doctors and patients, planned by the medical services that will be guaranteed and provided for citizens, directly contact healthcare institutions, assess and monitor the quality of the provided services, and so on. One of the essence of the reform is that the state, the government, will declare a guaranteed package of health services, medical services, and it will pay not for the healthcare institutions based solely on the size, but for the list of medical services and particular medical services, and for particular medicines that will be chosen by the patients. For 2017, the concept the concept of reform foresees the elaboration and adoption of main legal acts regarding the medical insurance, the guaranteed medical service package, the establishment of a single national procurer, in particular National Healthcare Financing Agency, And in addition, the Ministry of Healthcare of Ukraine is planning to elaborate and to implement the new model of financing of the healthcare institutions, the new model of evaluation the costs of medical service that will be provided for the patients, and the typical contracts between the National Healthcare Financing Agency and the only one institution responsible for the procurement of such medical services, via contracts with the medical services providers, and some others measures that you can see on this slide. Basically, it was the last issue within our webinar. I thank you one more time for your attention. We do understand that we ran out of the time, and we will be extremely glad to respond to all of your questions regarding any of the issues, any of the topics that we highlighted within this webinar. And you may contact us by any of the means that you can see on this slide. I mean, we will be pleased to get all your emails and telephone calls related to the issues within the webinar. I wish you a fruitful and energetic end of the day, and hope to see you or hear you soon.